Hey, what's up, everybody? It's Muggsy here. I was just wanted to do a video here on this document that was just released from the District Court of Northern District of California. It's a document about Ripple and Ripple's uh, filing of a motion to dismiss back in January. Then it's the ruling on that motion to dismiss. So, first of all, I just want to say that this is my first video, so I'm gonna kind of do things a little differently than what other I've seen other people to do. I'm just gonna kind of do a quick, brief summary of the video first. So if you want to stop listening at that point and move on to something else, you can. And then I'll do another like in-depth, uh, more kind of uh, why, you know, the details. So first of all, I just want to premise this by saying this ruling is not about whether XRP is a security or not. There is nowhere in this document that will tell you XRP is a security. There's nowhere in this document that will tell you XRP is not a security. Anyone that posts otherwise is either spreading hype or they're spreading FUD, or they just don't know how to read. Because a judge will not determine whether or not XRP is a security. That would be the Security and Exchange Commission, and they haven't done that. So there's nothing in here that will say, oh, the judge is leaning towards this or he's leaning toward that. No, the judge doesn't rule on that. He's just going to rule on these laws that we're going to talk about. So first of all, let's define who people are in this. The defendant here is Ripple Labs, also known as Ripple. There is also a defendant of XRP2, which a lot of people don't know exists. It's an XRP2 LLC, which is essentially a company that was created for the purpose of selling XRP. And then, of course, Brad Garlinghouse, the CEO of Ripple. So those are the three defendants in this case. So when I say defendant, that's who I'm talking about. And the plaintiff is the people trying to sue uh, the Ripple. So it's a guy named Bradley Sostak. Basically, Bradley bought XRP back in January 2018, sold it just a few days later, and in the court documents here, it says that he lost $118,100 in that short period of time. And we know that was January 2018. It was right after it spiked up. So, hey, maybe that happened. I know I've heard other people say before that, oh, it was only like $50 this guy had. Well, according to the court documents, it's 118,000. So I'm just telling you what's in this document, uh, not a bunch of FUD or fake or my opinion or anything like that. So we'll skip straight to the end, and I'll tell you, basically what this document says. Then I'll kind of go through it. Um, Basically, right here at the conclusion, this judge, basically all he's doing is making a decision on this motion to dismiss. So plaintiff says, "Hey, I want to sue Ripple." Ripple now becomes the defendant, and he says why he wants to sue Ripple. So Ripple and the other defendants, through their lawyers, file this motion to dismiss, saying, "We want you to throw this case out, Judge, because these are the reasons." They highlight 7 main points in here of why this case should be dismissed, and it shouldn't even go any further. And that's all the judge is ruling on, is that part right there, is whether or not just to dismiss this case now or let it continue going. Okay, you don't just file paperwork and it goes straight to court. There's this back and forth. So what the judge says here at the end is that these first and second causes, he denies them. So he's denying then Ripple. He's saying, nope, that's not a good enough reason to throw this case out. Third and fifth, denied. Nope, I'm not going to throw the case out for that. Fourth cause, oh, it's granted. Okay, but hey, there's leave to amend. So that means the plaintiff can now amend their complaint, and if they can satisfy uh, what I specify in this section, then I'll reconsider it. So these ones are already done. He made a decision on them. Done. Okay. This one, it's still open. It's granted for Ripple, right? So that's good for them, but it's still open because they can still file and amend it. Most of dismiss the sixth and seventh cause, also granted with prejudice, except as narrowly provided immediately above. So what he's saying is, okay, we're giving you this exception in this little teeny section, and that's where it gets interesting because that really pertains to securities and whether or not, now this document again that says doesn't say whether or not XRP is a security or not, but the plaintiff claim originally was that XRP is a security. So he's saying basically that uh, these rules that you're using, uh, you need to amend that to change that you're claiming XRP is not a security and you're still trying to do these things and prove these other things. So I'll go over that in greater detail right now. So that's the gist of it, the document. So if you want to turn it off, go right ahead. It was great having you watch me. I hope you come back again. Hope you like my video, whatever. But now I'll go through kind of this document a little more detailed and explain to you uh, some of this stuff. Now, I do want to say I'm not a lawyer, but I do have a lot of experience with legal documents like this. My background, I worked on a state level for federal programs. I ran programs on the state level, food assistance programs, emergency assistance programs, things like that. So I'm very familiar with taking um, state statutes and uh, 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 like the Code of Federal Regulations and those type of things, and translating those codes and take them and writing rules for the laws of states for their programs. So basically, I know how to read lawyer speak, is what I'm trying to say. So I'm not saying I'm an expert at it by any means or that I'm the best person out there, but I know enough to explain to you what this document is saying. So first of all, we'll go through the first what they call a cause for dismissal. So they're saying this is your first cause. So Ripple's saying this is a cause for dismissal. It doesn't meet this criteria, doesn't meet this. So we're going to just call it a reason. Here's Ripple's first reason. It says the defendants claim that even if XRP were a security, based on these other statutes that from rulings in the past, that you can't sue them 3 years uh, after, more than 3 years after the initial public offering to the public of the security. So basically, just it'll state, the relevant part of um, the documents that they're quoting from for the previous rulings from courts, and the reasons why, and at the end of each little section, so you'll see, hey, you got, okay, here's the B, here's the analysis of the claims, here's first section 1, subpart A, and if you go to the end of subpart A, you can see the basically the conclusion on this little section, because so all this is explaining, hey, this is what it's saying back and forth, um, what the defendant claims, what the plaintiff claims, and then here's the short paragraph. This is what you really need to skip to. In the absence of controlling North Circuit's report authority, the court has the discretion to choose the applicable rule for determining when this statute of repose commences. So basically, it's saying, hey, it doesn't have to be 3 years. It can be whenever the court wants it to be. So that's why they're throwing that first little part out. But there's a B part of this section too, um, which is basically uh, let's see, reason two. That basically, if XRP was a security, that he didn't buy the initial distribution of it. So they're also saying that this law says, hey, if it was, uh, it's got to be the initial distribution when we first sell it to people. That's what you got to buy. And in the end of it, again, the judge says, no, that's not really the case, according to this. So, it, so basically, he goes in and it goes under each of these separate little little pieces of this claim. So he also says in here, uh, the defendant Ripple tries to say that they're not sellers under this rule, that they're not the sellers because it was being uh, purchased from an exchange. But the judge quotes in here what's called a solicitation theory, and he's saying that you are considered sellers. And then he also adds that Ripple, XRP2 LLC, and Brown Garlinghouse are all uh, connected. They're all united. So if XRP2 sells XRP, so do the other two parties. So it's saying that yes, Brad and Ripple can be pulled into this lawsuit because that was another part of it saying if this is a lawsuit, it just should just be a part of this company that we set up, to handle these things. And the judge is saying nope, that doesn't work. So the this is the second part. That one we were just looking at that I was going through was all uh, that first part about whether it was the security, the 3 years, and the timing. Yeah, it was really long just to explain one thing. Um, and this second part is about the XRP being initial distribution. So that's part two. So part three says basically the defendants claim that um, if XRP were security, that one, uh, the plaintiff didn't purchase XRP directly from the defendants; they use an exchange. And the judge rules on that. Basically says, "Hey, I already explained that. You guys are the sellers based on the solicitation theory, uh, uh, and that you are the issuer by default because you put it on the exchange." So the judge is saying, hey, he's not kind of viewing it as you sold it to the exchange and the exchange is reselling it. He's saying it wouldn't be on the exchange if you didn't put it on there, and you obviously put it on the exchange for the purpose of selling it to somebody else, right? Because you post on an exchange to sell. So uh, that's what the judge said on that part. But there's kind of three parts. There's subsection A and B, and there's three parts of subsection A of this first part. So that was just the first part of subsection A. The second part says that the defendant and the plaintiff didn't meet the privity requirements. So that's down here. Now, privity requirements basically just means they have a legal or some kind of relationship that ties them together. So they're saying we have nothing to do with this guy. He doesn't. We have no legal relationship with him whatsoever. Um, and the judge rules on that and says um, he says a bunch of stuff, but he basically just says at the end it's obvious to the court even if the plaintiff can't prove it. So they were saying that not only do they not have a requirement, but the plaintiff can't even prove it, and he didn't even try to prove that they had a leak. So this will throw this whole rule out. And the judge says, no, he doesn't really have to prove that. He can prove that by just showing that he bought it and that type of stuff. The third little section here says that the sales weren't in California. Uh, so basically the judge says, well, okay, because this was the code that the California corporate code that they had stated in their filing, their suit against Ripple. So they're saying, well, this doesn't mean it because hey, it wasn't even in California. But the judge says, hey, listen, it's on a website. The guys in California, it's accessible in California. Ripple posted on their website how to purchase XRP, and with links to it and everything. So they're saying, it was sold in California. Uh, Again, this is not whether or not XRP is a security. Some of this is security law that we're looking at, but they're just arguing little pieces of the security law. Okay. So the B part of this basically says the defendant says that since XRP isn't a security, you can't include Ripple and Brad Garlinghouse in your claim. And the judge basically just says, I already talked about that earlier. Um, they're linked together. So the fourth section, this is basically uh, this one here is one of the ones that sections that were granted for Ripple, uh, but the first couple parts of it weren't. So basically, they made a couple claims that they had already talked about previously, and they just said, "I already talked about those. I'm not talking to them again about them again." So then the defendant claims in this section that the plaintiff did not prove misstatements were directed at him. So part of this law says that you know that they had quoted that these misstatements. Ripple is trying to say, well, it says that the misstatements have to be directed at him, and obviously we weren't directing any misstatements at him. The judge rules on that part and says, well, uh, I'm not gonna go there. I'm not gonna tighten the requirements of this claim. So I'm gonna go ahead and say that you know that doesn't need to be identified. We can, he could still sue you even if the claims aren't directed at him. But what he does say is the plaintiff fails to prove that there were any misstatements, and he goes to talk about what the plaintiff said. These different statements that plaintiff said. Um, Brad Garlinghouse tweets. They have different things quoted in here. And at the end of this, the judge basically said, um, "Well, you haven't said that any of these are misstatements." Uh, so here he talks a little bit. He mentions security. He says a statement that XRP does not qualify as a security is a position on a legal question, not an actionable misstatement. So they're saying that, hey, uh, so he was trying to say, well, Brad Garlinghouse said XRP is clearly not a security, so that's a misstatement. And he's saying, well, hey, that's a legal question. That's not for me to say. Basically, he's saying, hands off here. I'm not taking that as a misstatement because it hasn't been deemed whether or not it's a security. So, um, be careful what people pull out of this document. They can pull one little sentence and try and tell you, oh, it's saying this, but you got to look at the whole thing. You got to look at the whole thing. Um, so the last part here, um, it's kind of interesting because it is it's a section that does mention securities, but it still does not say whether or not XRP is a security. It's very interesting. I'm going to go through it. Basically, uh, he's saying the defendants argue that plaintiff failed to state claims under these statutes, right? California consumer protection statutes do not apply to claims alleging securities related violations. These statutes include a legal safe harbor. So it's just kind of basically him saying them saying that hey, it doesn't these don't apply to securities laws, right? Ripple's saying, so first of all, this guy's saying, "Hey, they're a security, and I'm suing him for security," and then he's quoting laws that say, "Well, uh, that aren't." aren't aimed towards securities. They're not aimed towards securities. So Ripple's saying you can't use these laws against us because we're XRP is not a security. So in the end, the judge basically says, "Look, uh, so he says, in the event XRP were factually determined not to be a security, so he's not saying it is or not. It's just saying if it was determined not to be, okay, and the plaintiff alleged the above referent misstatements with requisite rules specify those statements still may be actionable under this. So what they're saying, what the judge is saying, that if XRP is not a security, he can then prove these misstatements and still sue you under these laws for under, for example, a theory of false advertising. So eh, Ripple is trying to say he can't sue us because we're not a security, and the judge is saying, well, wait a minute. Even if you're determined not to be a security, then he could still sue you under these laws. So he's not throwing this part out. He's saying that the court allows the plaintiff to amend this section of their claim, but only under the alternative theory that XRP is not a security and with respect to the above referenced misstatements identified in the plaintiff's opposition brief. So the misstatements were uh, basically he was trying to say, all, remember all that list, Brad saying XRP is not a security, all those different things that were misstatements. The plaintiff needs to provide proof of misstatements and the reasons why they're misstatements, and he's got to amend his document to say to take out the whole security aspect of XRP. That's what this is saying. Now that's an alternative option. The other option is to prove uh, those other misstatements. So basically, this part was granted. So right now, the plaintiff has two options. He can go back and try and prove these misstatements, right, and get rid of this because this part uh, doesn't apply, or he can prove these misstatements, and also XRP would have to be deemed a security for him to win that way. Or he can prove these misstatements and change his whole thing to XRP is not a security, and therefore I'm suing him under these rules. Does that make sense? So he's got 28 days to do it. So at the end of after 28 days or whenever he files, usually they wait to the end. Um, then the judge will look at that, and then in another month or two, however long it takes, the judge will release his ruling on that. So this is still far from over. This is why court cases take a really long time. But I hope you enjoyed this video. I hope this is clear and understandable to you guys. Again, this is my first video, so any feedback is welcome. And I hope you guys enjoyed it.